Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit the like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share some love. All is appreciated. And the StreamYard link is down there for anybody who wants to join the panel. Tonight we're going to be talking about that motor vehicle theft prevention program done through the registration. First, we're going to tell you why, and that's for federal income tax purposes. And then I'm going to tell you how and why. And so let's get into the how and why. But first, let's enjoy an oldie but a goodie.
Hey, who are you?
Oh, hey, Jeff, What? I'm here at your car because, well, that's my job.
What? What? Oh, what?
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 What? And you got robbed. Paying for this could feel like getting robbed twice. So get all state. And you're better protected from mayhem. Like me.
All state. An oldie but a goodie. So if you're involved in the motor vehicle theft prevention program, why would you need insurance? My first question. But the why is for federal income tax purposes. Remember that. So let's get into the next one. The next one I've got set up here is 15 U.S. Code 44 definitions. And when it comes to those taxes and insurances, and of course, this is 15 U.S. Code is foreign trade and commerce. And then under that, they've got some definitions where they've got commerce, corporation, documentary evidence. Includes all documents, papers, correspondence, books of account, and financial and corporate records. Okay. The very first account is that enumeration at birth, the state's vital statistics jurisdiction. Acts to regulate commerce. Bureau of Vital Statistics, regulated by the Department of Commerce, and communicated in the first act of enumeration at birth by the translation of a legal name and the enumeration thereof. Antitrust Acts, an act to protect trade and commerce against unlawful restraints and monopolies, approved July 2nd, 1990. Also Section 73 and 73 to 76, inclusive of the act entitled An Act to Reduce Taxation for Federal Income Tax Purposes, to provide revenue for the government and for other purposes. And you can read the rest, banks, foreign law enforcement agency, da-da-da-da. Okay. Oops, I guess, how come we lost our sharing there? Ah, there we go. So we'll just go down again, 15 U.S. Code 44, foreign trade and commerce. 44 is definitions, commerce, corporation. Documentary evidence includes all documents from enumeration at birth, the very first ones, including the prenatal records that are extensive of mom's record, which are extensions of her mother's record, and father's, those paternity records and maternal records, prenatal records. Acts to regulate commerce, like I said, is Bureau of Vital Statistics, which is regulated by the Department of Commerce, and that is the first communication upon the establishment of the state's vital statistics jurisdiction by enumeration at birth. Okay, so let's look at Title 49 of U.S. Code Chapter 331, Theft Prevention. Now, this is Title 49, which is Administration of Transportation. 33-101 definitions. And then they've got theft prevention standard for high theft lines and theft prevention standard for other lines. These are the three main categories. These are for high line motor vehicles, expensive ones, and then other standards. Definitions. Chop shop, covered major part, existing line. First purchaser means the person making the first purchase other than for resale. That the United States purchasing as an importer fleet vehicles and then having the dealerships consign them. I don't know. See, they purchase them from the exporter. Line, major part, model year, new line. Last one, vehicle theft prevention standard means minimum performance standard for identifying major parts of new motor vehicles and major replacement parts by inscribing or affixing numbers or symbols on those parts. Vehicle theft prevention standard. Now remember, folks, these are just rules and stuff like that that were adopted for certain people that are associated with that administration. And you can apply voluntarily to use that same program, but you've been induced into something that you really don't need. And you'll see that later on as we discuss this further. So the next part is 28 CFR 29.1, purpose. And this is because this is Title 28, Judicial Administration, Department of Justice, Part 29, Motor Vehicle Theft Prevention Act Regulations. Now this is the CFR, and like I said, Title 49, which is the codification, sets the parameters for those that are associated with what they're supposed to follow. And then the Code of Federal Regulations is the enforcement of those codifications. 29.1, purpose. Purpose of this part is to implement contract terms and conditions required to implement statutes or executive orders - commercial items, commercial products, commercial services. So it has to do with contracting. It has to be some kind of commercial element about it. And you have to have some kind of corporate capacity. The Motor Vehicle Theft Prevention Act, 42 U.S. Code 14171. 42 is Social Security. However, it's been updated, so when we click on this and open that new window, and we go to this new window where it's 42 U.S. Code 14171, it says transferred. So we go down here to notes. It says editorial notes, codification. Like I said, this is just a codification. Section 14171 was editorially reclassified. So classification that's reclassified, that's a taxonomy. Look up the term taxonomy. It's a classification. So it's for income tax purposes. It's a taxonomy, classifications. That's all these are, rules for classification. As Section 12-611 of Title 34, crime control and law enforcement. Okay? It's no longer under Social Security and alleviates the Title 4D contract and sets it upon the crime control and law enforcement. Now, as we read this, we're going to find out that there are certain conditions and other conditions that may or may not apply, and that certain things are required to show that they apply. which requires the Attorney General to develop, in cooperation with the states, a national voluntary motor vehicle theft prevention program. Folks, it's national and it's voluntary. You understand? It's voluntary. Everything is voluntary. Taxes are voluntary. The motor vehicle theft prevention program is voluntary. The the Federal Motor Carrier Highway Safety Act is voluntary because you're not a motor carrier. Okay, that's something else we're going to discuss. Motor Vehicle Theft Prevention Program. The program will be implemented by states and localities. That means it's the states and localities that have a contract set up through their ordinances and their statutes. Those are contract terms and conditions required to implement statutes and executive orders pursuant to their commercial services and products as a matter of the interests at their sole option. Under this program, that's that records maintained on individuals through, again, the numeration at birth, implying that you're a person reasonably believed to be an eligible contract participant in those commodities and securities exchanges. Motor vehicle owners voluntarily sign a consent form. Again, it's voluntary. You have to apply through a consensual form. Indicates that the identified vehicle is not normally operated under certain specified conditions. And we'll read about one of those here in a bit. And agrees to display a program decal or license plate. Not both. It gives us a choice of decal or license plate on the vehicle and to permit law enforcement officials in any jurisdiction to stop the motor vehicle if it is being operated under specified conditions and take reasonable steps to determine whether the vehicle is being operated by or with the permission of the owner. Owner means the person or persons whose names appears on the certificate of title. We're going to talk about that too. There's another handwritten consent form that nobody's writing, and therefore the certificate of title is false. Certification is false. I've showed you that before in the tax code for federal income tax purposes. Or to whom the car is registered. Certificate of title, or to whom the car is registered. Again, one or the other. You can have a certificate of title or have it registered. One or the other, or both. These are options. Just like the state has an option, the people have that option. Article 10 of the Bill of Rights of the Constitution. You know, those powers not delegated to the Constitution of the United States, nor prohibited to the Constitution of the United States, are therefore delegated to the states, respectively, or the people. You have that same option. It's voluntary. In the instance of a new vehicle awaiting sale or lease, for income tax purposes, your consent to perform it or use the motor vehicle at least 50% of its use for trade or business. Again, we'll talk about that later. Or in the instance of a used vehicle, where the title has been assigned, again, it's a matter of assigning a title, a principal who can grant the assignment of a title to a trustee. So the assignment is to a trustee to hold the property for the beneficial use of the beneficiary. To a dealership, the trustee. The term owner shall be construed to mean new and used automobile dealerships, who the car is registered or titled to, vehicle awaiting sale or lease, as a used vehicle where the title has been assigned to the dealership. If they're the trustee already, and all they're doing is transferring the assignment of trustee, did you actually purchase that automobile? Did something funky happen there too? Maybe because you presented an ID that said you were already a trustee and were willing by a blank signature to just go ahead and take upon the liabilities. Oops. Agrees to display a program decal or license plate on the vehicle and permit the law enforcement, with the permission of the owner. The regulations set forth in this part establish the conditions under which an owner may consent. This merely establishes conditions, contract terms and conditions under which an owner may consent. You may contract. Contract terms and conditions required to implement. You may consent to implement. You may consent to contract. You can also dissent to contract. To having his or her vehicle stopped and the manner in which the state or locality may elect to participate. So it's giving the owner the ability to say, I have to consent, while allowing the manner in which the state or locality may elect to participate as a contractor. The owner may consent as a beneficiary, as a third party, taking advantage of that benefit in equal station, again, under the 9th and 10th Amendment. If you delegate that power for things on state business, for performing the functions of public office, as a matter of federal income taxes, for Federal Motor Carrier Safety Act, meaning you have to be a carrier, motor carrier, have a contract somewhere, and an oath of office, then you should be able to allow that for the same people that grant you those very powers of offices and agencies. That's all we're talking about here, folks. They have no right to license or restrict or limit the very powers that you delegate them, which are limited under equity, not to be used against the beneficiary deemed to be the true owner. Are you going to sell that vehicle? Most people will use a vehicle until they're done with it and then resell it. Oh yeah, I intend to sell it. That's your commitment. I intend to sell it. No, I intend to consume it, fully use it, and even maybe what do they call it? Recycle it. I saw a guy took an old farm truck and dismounted the cab and made a flower bed out of it, a sloping flower bed, had all kinds of flowers and stuff, had a little tree growing out of one corner, a small fruit type tree, and then had all kinds of flowers and stuff, herbs and spices, and then used the cab of the truck for a dog house. It was a great, took all the engine and everything out. Dog had the front nose where the engine used to be, had a nice seat in there, the whole 9 yards. Repurposing. What is the original purpose? What is your purpose of consenting? Do you have to use the state's motor vehicle theft prevention program or the federal motor vehicle theft prevention program? No, there are sections to that. It's called motor theft prevention products. You can show that you can use your own motor vehicle theft prevention products and not have to use theirs. So every time you park your car, you use one of them bars to lock the steering wheel. Sure, you might suffer damage, but it's not going to be stolen. So let's look at the next one. Definitions. The Act, Motor Vehicle Theft Prevention Act, owner means person or person whose name appears on the certificate of title or whom the car is registered. So again, in the instance of a new vehicle awaiting sale, we just read that. The program refers to the National Voluntary Motor Vehicle Theft Prevention Program. They cannot tell you you have to register your motor vehicle if it's voluntary. You have other options. Okay? You have other options. So let's take a look. The next one, administration by the Bureau of Justice Assistance. So we've got the Judicial Administration Department of Justice, and internally within the Department of Justice, there's a Bureau of Justice Assistance. Okay? Remember, that's a bureau. Bureau of Vital Statistics, State Bureau of Investigations, Federal Bureau of Investigations, Bureau of Justice Assistance, and the International Bureau, Director General of the International Bureau, relative to the Swiss Confederation of Federal Chancery, when we're talking about equity. Capital of Postal Service shall consist of the equity. Administration by the Bureau of Justice Assistance. The Director of the Bureau of Justice Assistance shall administer this program and shall issue guidelines governing the operational aspects of it, including the design and production of standardized, universally recognizable MVTPA reflective decal, as well as model consent and registration forms. So they are consent forms. Voluntary, not mandatory. You have options just like they do. The next one, 29.4, election to participate by states and localities. So just like they have the option to elect to participate, you have the option to elect to participate as well. Any state or locality that wishes to participate in the program shall register with the BGA and request program enrollment materials. For themselves, for the officers and agents, and this is where everybody gets screwed up. That term resident in the federal code 19 U.S.C. 81O, resident, no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. The board being the Secretary of Commerce. The Department of Commerce that regulates the Bureau of Vital Statistics, wherein first you are enrolled into an insurance program through the CMA, Center for Medicare and Medicaid Associates. It's an automatic qualification once you're born. Enrolled in multiple programs. Registration forms will be available upon request. Again, they are not mandatory. You're supposed to request these. Quit listening to these people that are telling you you are required to. Do your again, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. That's why I'm showing my research, folks. Participation in the program is wholly voluntary on the part of the state or locality. And if it's voluntary on the part of the state or locality, they cannot turn around and enforce something they don't have the authority to enforce when it's merely a voluntary participation. You cannot then turn around and tell everybody else they must participate because you do. By electing to participate in the program, a state or locality agrees to do the following: make program enrollment materials, including consent forms, available to interested motor vehicle owners. Collect completed consent forms. How many times does it say that they must have your consent? And your consent is voluntary in a national voluntary motor vehicle theft prevention program. Provide enrolled motor vehicle owners with the decals and license plates applicable to their program condition or conditions and instructions governing their program participation. Anybody receive those instructions? Did anybody give their handwritten consent on one of those forms knowing it was a consent form and give a handwritten statement of that consent? Your notice of intent of its use. Take the necessary steps to authorize law enforcement officials to stop motor vehicles enrolled in the program. So, to prove that you are enrolled in the program, you would have a plate and or decal or both. If you do not, it may prove sufficient evidence that you are not enrolled in the program, and therefore they are not qualified to stop. However, they give exceptions and necessities again. So keep paying attention, folks. Comply with any other regulations or guidelines governing participation in this program. That's to participate by locality, states and localities. 29.5, notification of law enforcement officials. In addition to the actions enumerated, as a condition of participating in the program, a state or locality must agree to take reasonable steps to ensure that law enforcement officials under its jurisdiction are familiar with the program and with the conditions under which motor vehicles may be stopped. Notice how short and succinct these are. And they're all in relation to the Judicial Administration, Department of Justice, Motor Vehicle Theft Prevention Act regulations. These are where they have the reasons the vehicles may be stopped. So pay attention. 29.6. Limited participation by states and localities permitted. A state or locality need not authorize the stopping of motor vehicles under all sets of conditions specified in the program in order to participate in the program. So they can participate in the program by authorizing just one set of conditions. Okay? All it takes is mere one set of conditions. 29.7. Are we paying attention, folks? Withdrawal from the program by states and localities. Any participating state or locality may withdraw from the program at any time by sending written notification to BJA, head of the agency. They're telling you the same place you give notification if you withdraw. You send your notification to the Bureau of Justice Assistance, letting them know that you are withdrawing from this program that they regulate. And by notifying participating owners individually by mail of the decision withdrawal. And by notifying participating states and localities individually by mail of decision withdrawal. So you're supposed to give them all notice. First duty of law is legal notice. Break the presumption and give them legal notice. The next one, 29.8, motor vehicle owner participation. In order to participate in this program, the owners of a motor vehicle must sign a program consent form and register with a participating state or locality. This is not saying that motor vehicle owners must participate. It's saying in order to participate in this program, at their option. The owners then of a motor vehicle must sign a program consent form showing by documentary evidence that they have, in fact, consented knowingly, willingly, and intentionally. If the vehicle is registered to more than one person, both owners must sign the consent form by enrolling in the federal program. So your registration at the state is an enrollment in the federal program. And again, it's for federal income tax purposes for federal motor carriers. But the traffic regulations are instituted through the state traffic laws under your state administrative codes that manage the vehicle assignment guidelines. Where's that motor vehicle MSO go to? It goes to the state, saying, hey, we just assigned this motor vehicle to one of your state trustees pursuant to the Social Security number they gave us. The owners of the motor vehicle states that the vehicle is not normally operated under the specified conditions. That's that other handwritten consent that you're going beyond the specified conditions that it's not normally operated under, and you're going to operate with intent to operate at least 50% of its use for your trade or business, which is the performance of the functions of trade or functions of public office, rather than for your own private use for family household goods. That the vehicle is not normally operated under the specified conditions, because normally it's operated at least 50% of its use for the trade or business. You understand the language of these codes as I'm showing you, you'll see what's going on. B, agrees to display the program decals or devices on the owner's vehicle. And remember, we're talking about program decal or devices. That's that plate that they were just talking about. That license plate. Remember that term credit card in 15 U.S.C. 4724? Credit card means any card, plate, coupon book, or credit device used to obtain money, property, labor, or services on credit. And when you display those program decals or devices on that vehicle, you're allowing that officer to come up in a program of economic warfare and issue a battle of the forms in his economic war. It's a chess game. You're on a chessboard. Law of the flag. Law of nations. Permit law enforcement officials in any state or locality to stop motor vehicle if the vehicle is being operated under the specified conditions. In other words, displaying the decal or devices during the daytime or during the nighttime. Displaying of them says that you're in the operation. That's what they believe. and take reasonable steps to determine whether the vehicle is being operated by or with the permission of the owner. So they're going to identify the vehicle with the owner. And then in so doing, certain documentary evidence is going to show that you're actually a contracting lessor of the property that has been pledged to the state and then leased back to you under an agreement to take on the tax ownership and use it at least 50% of its use for trade or business. Again, the performance of the functions of public office, which you've never taken an oath of office and therefore can't do so, and therefore creates an impossibility. And since you've never written such a statement, that goes to the subpart D there that says certification of title is false. The lessee must not know that certification of title is false. Now, why would they put something in the code like that? Perhaps because the certification of title is false? If the dealership is the trustee, does he have qualifications as a principal to then assign me as a trustee in the purchase of an automobile? No. He has requirement under trust law, public service, which is a public trust, to follow trust law. He's not supposed to mishandle, misappropriate the property that he's a holder of for any reason, particularly to his own benefit for private gain, at the loss of the consumer or customer. Oops. Expressly advise any borrower of the vehicle of the existence of this agreement. What if there's no agreement? And that such user will be subject to being stopped by law enforcement officials if the vehicle is being operated under specified conditions, even if the officials have no other basis for believing the vehicle is being operated unlawfully. You see their exception? Even if the officials have no other basis for believing the vehicle is being operated unlawfully. Ma'am, I'm only here to check the vehicle's VIN and the owner identification to see if you are said owner, and if you're not, if you have a proper valid agreement with the owner to do such borrowing. Comply with any other regulations or guidelines governing participation in this program. Governing participation in this program. Remember, they allow the states limited participation, states and localities limited participation. This is where that resident comes in, and they assume you're part of that participation, and therefore they're going to make you comply through the guidelines, vehicle assignment guidelines under the administrative code of the state. That's that motor vehicle operating lease, where you pledge it to the state under that certificate of title in agreement to use it at least 50% of its use. $29.9 motor vehicles for hire. Any person who is in the business of renting or leasing motor vehicles and who rents or leases a motor vehicle on which a program decal or device is affixed shall notify the person to whom the motor vehicle is rented or leased about the program prior to transferring possession of the vehicle. Did anybody get notification of the program? See, when they gave you that registration, that decal, they were supposed to give you notification of the program. Documentary evidence. The notice required. Now it's no longer consent. This notice is now required by this section shall be printed in bold type in the rental or lease agreement. Did you get said rental or lease agreement? And on the envelope in which the rental agreement is placed. So there's supposed to be somewhere a rental agreement with this notice sitting in an envelope with my signature on it. I want that document. I want it proven. The notice provision in the rental or lease agreement must utilize a larger font than the standard type in the agreement. The notice must state that the motor vehicle may be stopped by law enforcement officials if it is operated under the conditions specified by the program in which the car is enrolled, even if the officials have no other basis for believing that the vehicle is being operated unlawfully. So when they see a motor vehicle without plates, they honestly believe that it's being operated unlawfully and therefore will stop it. Imagine that. Imagine that. Failure to provide the notice required by this section to a renter or lessee may result in the assessment of a civil penalty by the Assistant Attorney General, Civil Division, or his or her designee of an amount not to exceed $5,000. They're telling you how much you can go after them for. I didn't get that notice. $5,000. No penalty shall be assessed. It's not a penalty situation. It's a lack of having the proper notice. And if they can't provide it because that envelope isn't sitting there with the notice on the envelope and the contract inside with the notice on the envelope or on the contract in bold, large font, then it doesn't exist. They didn't provide what was required. They failed. No penalty shall be assessed unless the person charged has been given notice and opportunity for a hearing of such charge. First duty in law is legal notice. I want a hearing to correct the records. It does not exist. Certification of title is false. I never gave such statement. It's not there. Every last one of these things requires such a statement. 29.10, owner withdrawal from the program. I mentioned this one before, and this is why I'm on this. An owner may withdraw from the program at any time by completely removing the program decal and changing the license plate if necessary. The owner is also encouraged to notify the participating agency in writing of such withdrawal. So we have a BJA, Bureau of Justice Assistant for the Motor Vehicle Theft Prevention Program. Motor Carrier Safety Act, that's the administration of the vehicle assignment, as if though you're a person reasonably believed to be an eligible contract participant, saying that you're a contract carrier, a motor carrier, a common carrier of some sort of passengers or goods, or providing services, and therefore you have a license or a ID. Your statement of intent in none of those exists. Your oath of office, license, nothing. You never made those. None of us knew that we were supposed to. In writing of such withdrawal. See, they're supposed to be in writing of such consent. Sorry. Next one. Sale or other transfer of an enrolled vehicle. Sale or other transfer. Remember when I said when you go to the dealership and you supposedly purchase that motor vehicle and they transfer the title in your name as a trustee rather than you purchase it through the proper process and end up with beneficial use and possession. There's a different way of transferring it. See, you can transfer it through a purchase or a grant. Remember we talked about that earlier in our trust. are revocable trust, irrevocable trust, charitable, what was it? A charitable charitable reversion trust or something, charitable remainder trust, things like that, where you bought a car new, and instead of selling it, see, that's that sale part. You intend to sell it. You tell them, no, I don't intend to sell it. I intend to grant it to somebody that could benefit from it. That's letting your cup welleth over. Instead of selling it, it's no longer for sale, it's for export. We're going to export it from the commercial system for our private beneficial possession and use. And when we get done using it to our benefit, if there's any use left in it, we're going to grant it as a gift to the benefit of somebody else, or we're just going to consume it completely and recycle it, like I said earlier, into something else. Sale or other transfer of an enrolled vehicle. Here they're talking about a bill of sale, and it says, upon the transfer of ownership of an enrolled vehicle, the transferring owner must completely remove the program decals, change the license plates if necessary. There's that same language again. And is encouraged to notify the participating agency in writing of the transfer of ownership of the vehicle. So it's not the guy that's buying the vehicle that's then supposed to go down and register it. That's voluntary. But the guy that used to own it under that title is supposed to give them notice, hey, I sold it or I granted it, one or the other. And then as a new owner, you don't have to enroll in the program. Just because the vehicle itself was enrolled in the program before because the other owners consent, you now need a new consent form from the new owner. Okay? The last one, and this is the entirety under Title 28 of the CFR of the Motor Vehicle Theft Prevention Program. Specified conditions under which stops may be authorized. Now, this is going to give the opposite sense of if you got that plate and decal on there, they can pull you over any time of the day, which is true. But this here gives them a specific reason to pull you over as a set condition. A motor vehicle, and there's only two of them. Remember, I said one or the other, and pay attention to the language here, because if you've got two conditions, you're supposed to have two decals and two plates. If you have three conditions, you're supposed to have three decals and three plates, according to the language. A motor vehicle owner may voluntarily enroll his or her vehicles and give written consent to law enforcement official to stop the vehicle if it is being operated under any or all the conditions set forth in this section. Any or all. And yet there's only two conditions. For each condition, the owners must grant consent and affix a separate decal, device, or license plate. So for one condition, you must affix a decal or license plate. The other one that you attach, you must also affix a decal and or license plate, or both. One condition is time. A motor vehicle owner may authorize law enforcement officers to stop an enrolled vehicle if it is being operated between the hours of 1 a.m. and 5 a.m. By enrolling in a program with this condition, the owner must state that the vehicle is not normally operated between the specified hours. So what you're doing is you're giving them consent to stop the vehicle during those times, 1 and 5 a.m., because it's not normally operated, and therefore it would be something abnormal, suspicious, check it out. Identify the vehicle and identify if it's really the owner operating it. If not, if the person operating it has the authority to borrow it. And that the owner understands that the operation of the vehicle between those hours provides sufficient grounds for a law enforcement officer to reasonably believe that the vehicle is not being operated by or with the consent of the owner. It gives them reasonable, articulable suspicion that a crime may be being committed, and that is motor vehicle theft. It's already there, and they can ID you. That's their reasonable, articulable suspicion. They don't want to tell you. And that the owner understands that the operation of the vehicle is sufficient grounds for a law enforcement officer to reasonably believe that the vehicle is not being operated by or with the owner's consent of the owner, even if the law enforcement official has no other basis for believing that the vehicle is being operated unlawful. The next one, border crossing or port entry. So now you're talking about within a mile of the border. A motor vehicle owner may authorize law enforcement officers to stop the enrolled vehicle if it crosses, is about to cross, or is about to be transported across a United States land border, or if it enters a United States port. For purposes of this section, the phrase about to cross a United States land border means the vehicle is operated or transported within 1 mile of the United States land border. Participating states or localities may implement this provision in accordance with local conditions. In other words, if you're in one of those border states of the United States, California, Oregon, Washington, Montana, Idaho, North Dakota, Wisconsin, Minnesota, Ohio, Idaho, or Indiana, along the way, all down the coast and then back, except for the centralized landlocked states, provided that the participating state or locality may not extend the applicable geographic area beyond 1 mile from the United States land border. By enrolling in a program with this condition, the owner must state that the vehicle is not normally driven across the border. So you got two conditions. One is time and one is border. So if you're in a landlocked state, then the border one doesn't apply. So it could only be the one. So the only time they should be pulling you over is 1 a.m. and 5 p.m. Unless I'm misinterpreting that. But please, if I am, and you know how to explain it to me, please tell me. I'm willing to listen. But the way that reads to me, they can pull you over between 1 and 5 a.m. That's the specified condition, because it's not normal to be operated during that time. So let's go on to 42 U.S. Code. Remember, I mentioned 42 U.S. Code 14171. We go here, transfer, go to notes. Section 14171 was editorially classified as Section 12611 of Title 34, Crime Control and Law Enforcement. So they just created the nexus instead of being with the Social Security, which is where it starts from, the enumeration of birth and the identification thereof, that Interstate Identification Index, FBI Fingerprint Index. So let's take a look at the state administration, like I showed you before, under Iowa Administrative Code 11-103.4, Vehicle Assignment Guidelines. So again, it's a matter of assignment. The state is saying they're the principal and you're the trustee that they assigned the motor vehicle to. And the principal gave you the motor vehicle to hold and benefit and not to commit fraud, waste, or abuse. And so when they find you in violation, whether it be a environmental control by not having a certain mechanism on your automobile or something for inspections or whatever it is, speeding, not wearing a seatbelt, they're operating under the Federal Motor Carrier Safety Act and the evaluation of the car to keep it in good use for the beneficiary, which you're not recognized as. You're recognized as the owner on that certificate of title, and that owner is a trustee position that's been assigned as such trustee. Again, you have to have an oath of office to be assigned as such a trustee, or have a knowing, willing contract with your statement of intent to do so. Neither of them exist. In order to maximize the average passenger miles per gallon of motor vehicle fuel consumed. This is the purpose. Fuel efficiency. Like I said, fraud, waste, and abuse. And at the same time, that fuel is a toxic chemical that can explode. It's an explosive. Vehicles shall be assigned on the following basis. EPA-rated compact sedans may carry 1 or 2 passengers and their personal effects. EPA-rated mid-size sedans or small sport utility vehicles shall carry 3 or more passengers and their personal effects. EPA-rated full-size sedans or mid-size sport utility vehicles shall carry 4 or more passengers and their personal effects. So we're talking about number of passengers and personal effects, consumer goods and family stuff, right? Cargo vans shall be appropriate in size and government weight for their primary use with regard to payload and cargo value. So we're talking about commercial use of products, commercial delivery of products. Excuse me. Mini passenger vans shall carry 3 or more passengers, their personal effects, and cargo that does not conform to the use of full-size sedans. 8-passenger vans shall carry 5 or more passengers and their personal effects. 12-passenger vans shall carry 7 or more passengers and their personal effects. 15-passenger vans shall carry 9 or more passengers and their personal effects. All the way through, it's been about the number of passengers, the cargo, and the personal effects. Pickups and sport utility vehicles shall be appropriate in size, government weight, and drivetrain, 2-wheel drive and 4-wheel drive, for their primary use with regard to trailering, payload, cargo volume, and on-off-road requirements. So again, for the cargo passenger or cargo space and delivery purposes, commercial intent. 2, vehicles that are made available for temporary assignment, such as departmental pool vehicles, shall be assigned in accordance with this rule. If an appropriately classified vehicle is unavailable, a larger available classification may be substituted. Other substitutions may be authorized in consideration of passenger physical characteristics or disabilities, or any other distinguishing circumstances and conditions as determined by the Fleet Services Manager. Remember, I told you this is a fleet service, military fleet. The Director of the Department of Transportation or the Executive Director of the Board of Regents for the vehicles under their respective authorities. Vehicles permanently issued to agencies or drivers shall be assigned in accordance with this rule on the primary use of the vehicle. So we're looking at that primary use of the vehicle, at least 50% of its use. And again, I'll show you that in Title 26 here next. That motor vehicle operator's lease. Certification is false because you never made that statement of intent of your primary use, that you would use it at least 50% or more. Primary use. The director may delegate authority to officials of the state and agency heads for the use of private vehicles on state business. This is the only thing they have, and it's in your state administrative codes for the assignment of private vehicles on state business. And they do this because you carry a state license or state driver's license saying that you could perform the functions of public office and commit to a primary use of at least 50% of its use for trade or business, which is the performance of the functions of public office for federal income tax purposes on state business, folks. No other reason do they have to compel you to register your private motor vehicle for anything, let alone conduct a motor vehicle operator's lease agreement where you commit to giving up ownership and taking upon a tax ownership under a lease agreement where the state leases that motor vehicle back to you upon a statement of intent of at least 50% of its use for trade or business. If a state vehicle has been assigned to a state officer or employee, this is that resident, federal, state, or municipal officer or agent. The officer or employee shall not collect mileage for the use of a privately owned motor vehicle unless the state motor vehicle assigned is not usable. So what this is telling us is that state officers or employees have assigned motor vehicles, or there should be motor vehicles assignable to them for that office or employment. Does that make sense? If a state vehicle has been assigned to a state officer or employee, that's telling you that's those fleet vehicles by the fleet service assigning motor vehicles to the fleet of officers and employees under a military government. The officer or employee shall not collect mileage for the use of a privately owned motor vehicle unless the state motor vehicle assigned is not usable. In other words, if there's no state motor vehicle assignable and they have to use a private motor vehicle, then they can get compensation returned for the use of their private motor vehicle on state business and get recompensed for mileage, just like a motor carrier can. I hope this is all making sense to everybody, because the next one is something I've gone over several times. Title 26 of the U.S. Code 7701, definitions. Person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. Partnership and partner includes a syndicate, group, pool, joint venture, or other unincorporated organization, through or by means of which any business, financial operation, or venture is carried on, and which is not within the meaning of this title, a trust or estate or a corporation, and the term partner includes a member in such syndicate, group, pool, joint venture, or organization. Unincorporated at this point. We're down here to 26. The term trade or business. The term trade or business includes, which means it excludes all else, and includes specifically, is justum generis, the performance of the functions of a public office. Okay? So let's go down here to subsection H, where it talks about Motor vehicle operating leases. And this is why they say you're supposed to have a motor vehicle driver's license. If you're in one of those things, you're supposed to have a driver's license. For the purpose of this title, in the case of a qualified motor vehicle operating agreement, same thing as motor vehicle driver agreement, which contains a terminal rental adjustment clause. Such agreement shall be treated as a lease if such agreement would be treated as a lease under this title, and the lessee shall not be treated as the owner of the property subject to an agreement during any period such agreement is in effect. So you got a certificate of title saying you're the owner, but then you've got a driver's license that says you're leasing that owned property. And so as a lessee, you shall not be treated as the owner of the property subject to an agreement during any period which such an agreement is in effect. And the agreement you undertake during that license is a time period. You pay a license fee to have a license for a certain number of years, a time period, the time during which such an agreement is in effect. Qualified motor vehicle operating agreement defined. For purposes of this subsection, which is Title 26, so it's a tax code, and this subsection would, of course, be for the purposes of taxes. It says, in general, the term qualified motor vehicle operating agreement means any agreement with respect to a motor vehicle, including a trailer, which meets the requirements of subparagraphs B, C, and D of this paragraph. So, B, the minimum liability of the lessor if the state takes ownership, and they are the lessor, and it says an agreement meets the requirements of this subparagraph. If under such an agreement, the sum of the amount the lessor is personally liable to repay, and the net fair market value of the lessor's interest in any property pledged as security for property subject to the agreement. As I said, when you register that motor vehicle voluntarily under the National Voluntary Motor Vehicle Theft Prevention Act, you're actually pledging it to the state so they can keep track. It's a tracing and tracking of the owner and the VIN number of the vehicle, so they can track the owner and the vehicle to make sure they stay matched up. You can do that yourself. You don't need them to keep track of your property. So therefore, you can keep your property, keep track of it yourself, instead of keep pledging it to the state so they can keep track of it and enforce the tracking against you, because you're not considered the real owner. Equals or exceeds all amounts borrowed to finance the acquisition of property subject to the agreement. 48 CFR 52.212, again, contract terms and conditions required to implement statutes or executive orders - commercial services, commercial products. They don't have any interest. There shall not be taken into account under Clause II any property pledged, which is property subject to the agreement, or property directly or indirectly financed by indebtedness secured by the property subject to the agreement. There shall not be taken into account under Clause 2. Shall not be taken into account the net fair market value of lessor's interest, because they have no interest anyway. They didn't finance it. They just demanded that the property ownership was in the state, and therefore they're going to hold title and they're going to sign it back to you as a lessee and take profit. Yet they don't get any profit because there's no proceeds because you never pay them rent, do you? Or is that the registration? How does that work? So you're supposed to be signing rental agreements and consent forms and oaths of office. Oh yeah. Equals or exceeds the amounts borrowed to finance the acquisition or any property pledged, which is property subject to the agreement. Your automobile pledge, which is subject to the agreement, or property directly or indirectly financed by indebtedness secured by the property, subject to the agreement. This is the interesting part because this is where you're supposed to certify it. Certification by lessee, notice of tax ownership. So you gave up ownership of the motor vehicle and exchanged it for tax ownership. That's what this is stating. The lessee shall not be treated as the owner of the property, subject to an agreement during any period such agreement is in effect. You shall not be treated as the owner of the property. But you got to certify by lessee and be given notice of taking on a tax ownership. An agreement meets the requirements of this subparagraph if such agreement contains a separate written statement, separately signed by the lessee, you, under which the lessee certifies, under penalty of perjury, that it intends that more than 50% of the use of the property subject to such agreement is to be in a trade or business of the lessee. Trade or business is the term. Trade or business includes the performance of the functions of public office, folks. You cannot give said handwritten statement of intent if you do not have an oath of office. Therefore, you cannot use it or give it a primary use of trade or business, at least 50% of its use, which clearly and legibly states that the lessee has been advised. Somebody has told you or given you some documentation and told you to read it. This is your advisement. This is your caveat. That it will not be treated as the owner of the property subject to the agreement for federal income tax purposes. And then the last one that busts the nut all over them. Lessor must have no knowledge that certification is false. Now, why would they put that in there? Because obviously there are cases where it would be false. You know, where under which the lessee certifies under penalty of perjury that it intends more than 50% of the use of the property subject to such agreement is to be in trade or business of the lessee, and that must be done in a separate written statement separately signed by the lessee. If you never did that, then it never happened. Therefore, the certification is false. Not only is it false, but it can never be true unless you can come upon the abilities of taking upon that oath of office, as explained for trade or business to perform the functions of a public office for federal income tax purposes. And I looked up Mississippi. This is the Mississippi Code, Administrative Code, and it talks about leased vehicles. Any leased motor vehicle which comes into the state of Mississippi In other words, you have to have a contract with the state of Mississippi again. There have to be terms and conditions required to implement. And under the statute of this state, to implement those statutes of this state, is required to have placed thereon a Mississippi license tag. In addition, must also be titled under the provisions of the Mississippi Motor Vehicle Title Act. The title certificate will reflect the true facts and the legal title in the party which actually holds the title. So again, if the true facts require, in order for you as a lessee to hold a certificate of title, and the true facts hold that you have to have a handwritten statement of your intent, separately signed, that you're going to use it at least 50% of its use for trade or business, which is defined as the performance of the functions of public office, and you don't have said oath of office, it is an impossibility. In the event motor vehicle is the subject of an agreement for the conditional sale or laws thereof, with the right upon performance of the conditions stated in the agreement, and with the immediate right of possession vested in the conditional lease, then such conditional lease or lessee is considered the owner, and the registration and title is issued in the name of lease. So the certificate of title is evidence of a lease. The lessor holding a security interest in a vehicle is recorded on the certificate of title as lien holder. So the state is claiming that they're the lien holder on it, and you're the one entrusted to conduct or operate that motor vehicle in accordance with the statutes and not violate them. If you do, the state holds an interest in placing a lien on that motor vehicle and can take it back as the owner, the primary owner, with the security interest of enforcing the security itself, the motor vehicle, pledged as security for that very same agreement. If the lessor has given security interest in the vehicle to a bank, finance company, etc., that bank or finance company would be the second lien holder. This type lease will hereafter be referred to as a purchase lease. Non-titled vehicles required supporting documents. When applying for a certificate of title on a used vehicle that has not been previously titled, the following supporting documents must accompany the title application. So are you required to have a certificate of title if it's a title application? Are you required to have a certificate of title if it's a title application? And remember, a grant or a trust shall not fail for want of trustee. So if one person grants it to another, like I said earlier, if I purchase a motor vehicle, clean title and all that, and I use it for a certain number of years, I don't have to resell it. I can use it to its ends, or to full consumption, and or recycle it, or I can grant it to somebody else. That's a grant in a trust action that doesn't require a trustee. It's just a simple gift from myself to somebody else. No bill of sale required, because we don't have to apply for a title. We can have private documentation that shows the grant in a trust, which doesn't require a contract. The next one is the Mississippi Motor Vehicle Rules and Regulations. The last one was the Administrative Code, talking about lease of motor vehicles. Now here's talks about access to Marvin, motor vehicle records disclosure. Marvin is what? Tells us somewhere. Mississippi Automated Registration Vehicle Information Network, Marvin. Mississippi Automated Registration Vehicle Information Network. Subpart 2, tags, chapter, title. 1. Private carriers of property. Private carriers of property. I'm not a private carrier. I'm sojourner, and I have a temple which allows me to possess a certain number of my belongings as I go along those travels. Rental vehicle tags. Motor vehicles owned by non-residents. Again, that's ownership rather than possessed or used. Registration. Where to register vehicles. That's all it talks about here. Dealers and designated agents. Submission to title applications. Revocation of designated agent authority. Revocation of designated agent authority. The commissioner may revoke the designated agent status of a designated agent when the designated agent fails to faithfully perform those duties imposed by the motor vehicle dealer tag permit law. So if it's a motor vehicle dealer tag permit law, then it applies to the motor vehicle dealers, not us. So anyway, wanted to go through that information. I hope you guys are paying attention. I know I went through it kind of quick, but it kind of shows you how things are kind of tied up. Maybe I'll go further into the Motor Carrier Safety Act next time. But that's the truth of it. You're the one with the license and IDs. Those are state instrumentalities saying that you're working for the state as principal and you're the agent. Don't have to ask them for the oath of office, Laura. All you have to show them is that there's a requirement for an oath of office. If they're saying that under a motor vehicle operator's lease, which is the same thing as a motor vehicle driver's lease, which explains exactly the certificate of title and why you have that certificate of title and that you've given up ownership to the state. I mean, it's pretty much self-explanatory there. The caveat is Title 26. The lessor must have no knowledge that the certification is false. Why would they put in their code, just like the spell of illness in the Social Security Health and Welfare Code, 42, Title 42, U.S. Code 1395X. It's a set of definitions, and the very first one says spell of illness. Why would they tell you that there's a definition called spell of illness? Because it's a warning. It should catch your attention. Lessor must have no knowledge that the certification is false. Well, that tells me that somewhere along the line, they've come across certifications that are false. How is that so? I'm going to tell you that many of those certifications are false because you're supposed to make an agreement meets the requirements of this subparagraph if such agreement contains a separate written statement separately signed by the lessee under which the lessee certifies, under penalty of perjury, that it intends knowingly that more than 50% of the use of the property subject to such agreement is to be used or be in a trade or business of the lessee, wherein trade or business is defined as the performance of the functions of public office, and yet there is no record of it, no oath of office, nor is there a mileage record showing the mileage, at least 50% of the mileage has been used during that performance, nor is there a time log showing at least 50% of the time it was used that it was on performance of. There's no business schedules, no time in, time out, clock in, clock out, no points of delivery, point of origin, final destination where you delivered any products or committed to any services at a delivery or service address. None of it exists. Oh, and you know how your registration drops every year because the value of your automobile drops? That's the fraud, waste, and abuse part. It costs you less to re-register it because it's not quite as valuable now. So you only have to pay a smaller amount because it's a smaller percentage of its actual value now that you're still using it. See, it's no longer in its primo shape for the beneficiary to receive. You're depleting something that the beneficiary is supposed to be using. You're supposed to come up with a remedy. Charitable remainder trust, irrevocable trust, granting the property or selling the property to a trust instead of holding it in a state. When they ask you in court, are you currently employed, Mr. Smedley? Oh, yeah, that's a good one. I don't have a job, but I do plentiful work. Well, where do you work? Everywhere I go. It's a lot of work putting up with people like you. You. Christopher knows what I'm talking about. Anyway, I want to thank everybody for your support. Please hit that like, share, and subscribe button on your way out. There's a PayPal link down there for anybody who wants to share some love. And of course, again, don't believe me. Don't believe your neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your homework. Do your research. Do all that so you know. And remember, oops, I gotta get to it here. Let me get to it. Here we go. Remember, folks, motor vehicle theft prevention.
Hey, who are you?
Oh, hey, Jeff,
What?
I'm here to your car because, well, that's my job.
What? What? Oh, what?
What?
What? What?
And you got robbed. Paying for this could feel like getting robbed twice. So get all state. And you're better protected from mayhem. Like me.
Are you in good hands? Come out of the mayhem. Don't believe me. Don't believe the neighbor. Don't believe the government, for crying out loud. Don't believe your mother. Do your research so you know. Quit getting into all those accidents. And remember, folks, I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see everybody next time. Bye now.